Thank you for the opportunity to testify today. It's an honor to be speaking before you and the committee and alongside my distinguished co-witnesses. Beijing competes with co-option, not confrontation. The Chinese Communist Party does not directly attack its adversaries' systems. Instead, Beijing seeks to subvert them from the inside, such that they advance Beijing's agenda rather than obstructing it. In the military domain, for example, China positions to control critical information systems, value chains, even political stakeholders, such that it can decide where missiles are positioned and how they're perceived, rather than having to launch them itself. In trade, China has not sought to supplant the World Trade Organization, for example. Instead, Beijing has sought to manipulate it by holding others to its rules without following them itself, such that China can weaponize international free trade. And inside the United States, the Chinese Communist Party uses the American legal system to advance Beijing's agenda, punish its opponents, and neutralize U.S. defenses. Benefiting from the reality that China's centralized, opaque system allows it to out-resource competitors in courts, to co-opt key stakeholders, and to manipulate information. This poses a threat to American security and prosperity. Offensively, Beijing works to shape U.S. laws and regulations and their implementation, in many cases via U.S. entities that have been co-opted by dependence on or resources from the PRC. Beijing has also proven its willingness to use the U.S. legal system to punish those who stand in its way. Beijing does so, for instance, with SLAPP lawsuits that are intended to censor and intimidate critics by burdening them with costly legal defenses. Beijing also does so with IP lawsuits that, through the discovery process, granted access to valuable technology. And on the flip side, China provides IP litigation funding for its companies in order to protect them from facing the consequences for their tech theft. Beijing also defensively games U.S. laws and regulations, circumventing and neutering American efforts to defend against Chinese bad practices. In response to U.S. tariffs and other trade restrictions, for instance, China transships through third-party countries, often obscuring country of origin. China also localizes in countries that have preferential trade relationships with the United States. And China localizes in the United States. Doing so allows Beijing not only to avoid U.S. trade restrictions, it also allows China to benefit from preferential policies that are intended to support U.S. domestic and partner industry. Moreover, localization in the United States allows Beijing to maintain and to expand its united front, the network of co-opted stakeholders through which it undermines the U.S. system from the inside. This entire program, offensive and defensive, benefits from Chinese government resourcing. Directly and indirectly, the Chinese state provides the resources necessary for its agents to outlast and outspend their competitors and their targets in U.S. courts. The Chinese state also provides subsidies and guidance for go-out companies such that they can expand their presence abroad. And the Chinese state provides policy insurance mechanisms that are intended to de-risk investments that might be vulnerable to regulatory hurdles, as well as instructions for navigating U.S. procurement and policy. Because Chinese abuse of the U.S. legal system is systemic, it demands a systemic response. Tactical measures, like anti-SLAPP legislation and protections to defend American companies from exposing their IP to China via discovery are important, but the U.S. response cannot end there. Chinese and Chinese-backed entities should have increased information sharing and transparency requirements when bringing cases. Those receiving direct or indirect funding from the Chinese government should face a higher pleading standard in the U.S. So should American entities that work with them. U.S.-based actors that engage with Chinese state-backed and government-linked players operating in or importing into the U.S. market should have to disclose as much. Law firm and lobbyists that work with those entities should not be eligible for U.S. federal government funding or defense industrial-based procurement. More generally, sovereign immunity should not be extended to PRC entities. Foreign entity of concern provisions should be expanded to apply to all government authorities and support programs, and strengthened with presumptions of denial. Across the board, the definition of a Chinese entity should be tightened such that Beijing cannot circumvent through shell companies, joint ventures, or localization. China is an adversary. This has been internalized in the United States, if belatedly. So has the strategic imperative of decoupling from China economically and industrially. But to do that, the United States also has to decouple its legal system. Thank you.